All right, good afternoon, and thanks to all of you for being here. I'm here to announce that just a few minutes ago, the Metropolitan Government filed a lawsuit seeking to enjoin the enforcement of the Metro Council Reduction Act that was passed by the legislature last week. We are seeking an injunction. We are asking the court to move expeditiously. At the very outset, let me say that this is very likely the most important lawsuit in the history of the Metropolitan Government. Metropolitan Government has been in effect for 60 years, and I cannot think of another lawsuit that is more important than this one. As you recall, the legislature passed a bill that the governor signed into law on Thursday. That bill forces Metro to reduce the size of the Metropolitan Council from 40 members to a maximum of 20 members. We have two different paths to justify an injunction from the court. The first is simply a timing issue. It is too late, based on existing precedent very recently from the Tennessee Supreme Court. It is simply too late to be changing the rules for an election that has already started. Secondly, the path involves multiple constitutional defects based on the Tennessee Constitution. So let's take a look at the timing issue first. This election's already underway. As everyone knows, we are in the middle of an election for the Metro Council as well as the mayor and vice mayor. More than 40 candidates have already filed papers appointing a treasurer and giving them the ability to start raising money. Some of those candidates filed that treasurer appointment form 2 years ago. The qualifying deadline is on May 18th. And ahead of the qualifying deadline on May 18th, the Election Commission is to make petitions available to candidates a week from today, on March the 20th. So this election is already underway. And in a similar case, just last year, you will recall that after the 2020 census, the legislature redrew the lines for the State House and the State Senate. And they put those lines out there and the election started. There was a lawsuit that was brought based on a constitutional claim that the state Senate districts were not sequentially numbered in Davidson County. That case went in front of a trial court, and the trial court issued an injunction saying, you're right, this is a constitutional violation. The legislature must redraw the lines. The Tennessee Supreme Court quickly moved in to exercise its emergency jurisdiction is the court of final resort, and the Tennessee Supreme Court vacated that injunction, said that the trial court was in error to issue it. What's the reason? The main reason was the election is already underway. It is simply too late to change the rules. That decision from the Supreme Court came down in early April of the election year that was already in progress. Based on that precedent alone, this lawsuit the injunction should be granted. Based on that precedent alone, the court should enjoin this statute. The constitutional issues are also significant. In 1953, the Tennessee Constitution was amended following a constitutional convention. The main problem that led to that convention was because the legislature was affecting what was happening at the local level. They were changing salaries of local officials. They were changing the terms of local officials. So the Constitutional Convention was called to address that exact issue. And the Constitution was amended to prevent the legislature from doing that. Those bills that interfered with local legislators, with their salaries, with their terms, those bills were called Ripper bills. Well, this act is a Ripper bill. It violates the constitutional amendments that were adopted in 1953. We believe that there are several constitutional defects. Those defects could have been remedied if the legislature had adopted an amendment that was drafted by Senator Yarborough and introduced in the House by Representative Clemens. That amendment would have done two things. It would have said, this bill does not go into effect until the voters of Metro have a chance to approve it. And only if the voters approve it, then the change in the council size would go into effect in 2027, giving us plenty of time to do that. Well, the amendment was voted down in the House. The amendment was voted down in the Senate. If they had passed that amendment, we would not be here today because the bill would be constitutional and without objection from the metropolitan government. The 1953 constitutional amendment also contains what's called the consolidation clause. And the theory goes like this. After 1953, the voters in the cities and the county of a county can decide that they want to merge the government into a metropolitan government. One government, it has to be approved by the voters in the county and by the voters in the city. And once that happens, based on the Constitution, there is a pact that's created between the voters and the charter and their government. The state legislature cannot change that charter, which is based on the Constitution and the authority given by the voters without asking for voters to approve it. Now, we've heard a lot from the legislature in the last few weeks about how local governments are the creature of the state. Well, that much is true. Metropolitan government is a creature of the state. But then we've also heard that the state legislature can change the local charters anytime it wants, and it has total authority to do that. That is flatly wrong. The state legislature does not have the constitutional authority to come in and change our charter without our approval. We are a creature. Metropolitan government is a creature of the Tennessee Constitution. The legislature is a creature of the Tennessee Constitution. That's where we both derive our power. The legislature cannot do this in a way that violates the Constitution. Finally, we have a remaining constitutional argument. If the Metro Council by May 1st does not adopt new lines, the term for existing council members will be extended. Those terms will be extended for 1 year. And then in August of 23, the voters will elect council members for a 3-year term. Well, that is flatly unconstitutional. In 1977, we had another constitutional convention. There was an amendment that came out of that. It's Article 7, Section 1 of the Constitution, and it says, in plain English, members of the legislative body of a local government shall be elected for terms of 4 years. Members of legislative bodies of local government shall be elected for terms of 4 years. Not for a term of 5 years, not for a term of 4 years. So the Constitution is really clear. It could not be more clear that this provision, which seeks to add a year to the current council members' terms, that is flatly unconstitutional. The metropolitan government truly regrets being in this position. There are 3 branches of government. We first took our concerns to the legislative branch where they were ignored. The amendment that we've discussed that would have addressed our concerns was voted down, almost exclusively on a party line vote. It was voted down. And then before we could take our concerns really to the governor, he signed the bill, and we went to the legislative branch. The governor, being the second branch of government, did not pay attention to our constitutional concerns. We literally have no choice but to go to the courts, the third branch of government. The courts have a long history of enforcing constitutional rights. Again, we did not ask to be here, but we had no choice. We are asking the courts to enjoin the statute because it's too late and it violates the constitutional rights of the metropolitan government and the people who live here and make a life here. For that reason, we're filing our lawsuit. I'll be glad to take questions.
What is the court of last resort?
Tennessee Supreme Court.
Do you expect that Republican-appointed court to rule in your favor?
Yes, because the law is really clear. This is not a political issue. I'm not here talking politics. I'm here talking constitutional law. And the Constitution could not be clearer on this. They cannot do this without giving us a chance to vote, and they cannot extend terms for a term other than 4 years. So the Constitution's clear. We expect to win. Kathy.
How likely is it that Metro would be able to redistrict in time for the August 3rd election? Why or why not?
Okay. Good question. There are so many parts of how to get ready for the election. So under this law, we have 30 days, only 30 days, for the Planning Commission to do its job and draw lines. And the 30 days is clipped short because before they can do that, the council has to first meet and say, okay, we want you to draw lines for 20 members or maybe 17. Or they can say 15, or draw lines for 17 districts and 3 at large. The council first has to direct the Planning Commission on how to draw the lines. Only then can the Planning Commission complete its work, submit maps, and they have until April 8th to do that. We have 2 significant concerns about that. One is the Planning Commission just went through this process 1 year ago, and they met for months with neighborhood groups, with affected individuals, trying to make sure that they did not artificially divide communities that naturally were bound together by common interests. It took months. The other piece of this, and I cannot emphasize this enough, there are significant implications of the Federal Voting Rights Act in this case. We tried to raise those concerns with the legislature, and again, they were ignored. The 40-member council was part of a deal that was made between various constituencies in the county to make sure that the Metro Council would have adequate minority representation. The council had minority representation from the beginning in April of 1963, and today the diversity on the council is something we are proud of and is really important to the people of this county, and it has been for more than 60 years. In fact, the first time Metro was up for a vote was in 1958, and it was voted down. And a lot of people believe it was voted down because the council under that charter would have had only 21 members. So that was expanded to 40, and then only then was the charter voted in by a majority of the voters. So that analysis is really sophisticated. You cannot do it in two weeks. It takes more time. Sure, the Planning Commission could put into its software, okay, we have all these voters, divide it by the number of districts and give me a map. They could do that the second. But it doesn't do what they need to do to take into account what the voters here want, what the voters need in their representatives, and the Voting Rights Act. So that's just the first phase. Then, let's assume that they did that by April 8th, and the council, by May 1, adopted those lines. Say that they do it on May 1, which is the deadline. The qualifying deadline is May 18th. You have candidates who have been out there for 2 years campaigning to be, for instance, I want to run for council in District 27. Well, District 27 won't exist anymore. So candidates are going to have to look first to say, okay, where do I live? Am I in one of these districts? Yes. Where do I run for office? It's not fair. It is simply not fair to those candidates and the people who have been involved in those campaigns to change the rule and say, you have 17 days to qualify in whatever district we throw you in because the state has made us do it. It's simply not fair. And then after that, even after that, assuming that happens, the Election Commission has to make sure that the voters line up in the districts that are approved by the council. And we saw just last year how complicated that is. And last year, there were mistakes made. Several hundred voters were put into the wrong district and essentially were disenfranchised because of a mistake made because things were rushed. Well, last year, there was a much longer time to do all of this than this year. So the Election Commission will have to send out voter registration cards, which means that any person who lives in Davidson County, many of them will have had 3 different voter registration cards in 12 or 13 months. The card that existed before the redistricting last year, the card that they got last year after the redistricting, and then the new card that they get sometime this summer, hopefully before August 3rd, telling them where they now live, in which council district. It's chaos. It cannot go forward. There is no reason to implement these changes on this timetable.
What is your desired outcome for this lawsuit? Is it that the council stays at 40 members eventually, or that if the reduction happens, it goes in a more manageable way?
Well, look, I have a personal view, which is I believe it's important to honor the 40-member council that was part of the original creation of Metro for the reasons I said, to assure adequate minority representation. That's a personal view. My legal view is that the issue of whether our council is 40 or 20 or 27 or anything in between is a matter for the voters. And the voters need to decide that issue. And so that is our goal. This bill cannot be implemented because it is too late and it violates the Constitution and should be declared void.
What is the impact of this law on the real person out there that lives in Nashville, lives in Davidson County, and doesn't maybe pay attention to the Metro Council? They might vote every 4 years on who represents them. How will this law, if it's implemented, impact them?
They will be very confused because they will have gotten a voter registration card a year ago that says you live in Council District 28. District 28 may not exist. They'll get a new card that'll say, oh, now you're in the new district, whatever, 15. That will create confusion. The other thing that it does for the average voter is it means instead of having a council member who represents 20,000 people, more or less, your council member now represents 40,000 people, or maybe more. And so your ability to be heard by your council member is definitely reduced. There are, I believe, several hundred mayors in Tennessee who are mayors of cities less than 40,000. So it will affect those people 2 ways off the top of my head and probably other ways.
Can you speak to the broader context here? This is obviously not the only, this became law, but there are other bills aimed at targeting Metro and the city of Nashville. Are you prepared to file more lawsuits if this legislation moves forward? And what does that mean for the working relationship with the state?
First, let me say, we did not start this fight. We are filing a lawsuit because we have to protect our constitutional rights. We didn't want this. We didn't want any of this to happen. We tried with back-channel communications. We tried with efforts from our Nashville delegation. By the way, let me say real fast, I meant to say this earlier. Our Nashville delegation in the legislature did an incredible job representing the interests of metropolitan government, and I am grateful for their work. So we do have these other bills out there. There are several. We have significant concerns about all of those bills directly affecting Metro for some of the same reasons, whether or not they are constitutional. We're having discussions. We're hoping that those bills can be amended in such a way that we will not have to file a lawsuit, but we are reserving the right to file a lawsuit if they do a bill that's unconstitutional. You know, that is a great question. When you're living in it, it's hard to know when you were in the middle of an inflection point in history. But it's pretty clear this is an inflection point in history. The future of the relationship between the state and the metropolitan government will be dictated in large part by what happens in this lawsuit. And we are either going to have a future where the legislature can do whatever it wants to do without regard for our rights, without regard for the people who live here. That's one option. The other option is they have to respect our constitutional rights. So I think there's a chance that the courts will bring some definition to this relationship. And we're asking the courts to acknowledge the fact that 700,000 people plus live in Davidson County. They have decided to make a home here. Many grew up here. Many others came from other places and decided to make this a home. So when we talk about the Home Rule Amendment, it is protecting the rights of those 700,000 people who chose to make Metro Nashville their home. We are protecting their interest to decide how they are governed at a very fundamental level. So you say, how does this affect the relationship? I think in some ways there's a chance it improves it.
Any last questions?
You expressed, you mentioned the precedent in the case of the districting lawsuit, but there's another precedent in the voucher lawsuit where the city made similar arguments about home rule and the Supreme Court rejected those. Do you think that gave a green flag to lawmakers to do as they will on all these other bills, including this one about the county side?
The questions are great today. Thank you for all these questions. If you look at the voucher ruling on page 8 of that opinion, all 5 justices reinforced their respect for the Home Rule Amendment, saying that is the law. It's an important part of the Constitution. There were 5 votes for that out of 5 justices. It was unanimous. The Home Rule Amendment is very important. The court went off on a 3-2 opinion saying, as a factual matter, almost a technicality, the Voucher Act does not, quote, affect Metro, which is the language in the Constitution. Does this bill affect Metro? The Supreme Court found by a vote of 3-2 that the voucher bill did not affect Metro because it affected the metropolitan Nashville public school systems. We disagreed with that factual finding, but the core principle that the Home Rule Amendment must be honored was affirmed by all 5 of the 5 justices. We anticipate the court will uphold the Home Rule Amendment.
When do you either expect or hope this to be brought up and have a decision by?
I'm sorry?
When do you expect this or hope for this to be brought up in the court and have a decision?
So here's the process. Under a relatively new law, if anyone challenges a state statute alleging that it's unconstitutional, that case is filed in the court where the plaintiff is. We have filed in Davidson County Chancery Court. And under the law, we are obligated to file a notice that we are challenging the statute based on state constitutional grounds. And so that triggers a 3-judge panel. The Tennessee Supreme Court will appoint a judge from West Tennessee and a judge from East Tennessee. Those 3 judges will sit and hear the case at the trial level. We are asking the courts to expedite this process at every step of the way. We're filing a motion asking the courts to expedite. We notified the clerk of the Davidson County Chancery Court, the clerk and master, that we were doing this today. Notices have been made to the clerk of the Supreme Court. They will not be surprised. We are asking that that 3-judge panel be appointed and they schedule a hearing on the injunction as soon as possible. That will obviously take a few days. It will take a little bit longer than it would if we were just dealing with one chancellor right here in Nashville, but we are asking that it be expedited to the extent humanly possible. Questions have been good. Any other questions? All right, again, I just want to say, I don't believe there's a case in the history of Metro that's more important than this one. The outcome of this case will determine the history of state and local relations for decades to come. So we ask the court to protect our rights. Thank you very much.